SJC-11442, Commonwealth versus Tyrone Staley.
All right, let's proceed, please.
Good morning, Your Honors. Shoshana Stern for the Commonwealth. Your Honors, this is a case in which a judge allowed a motion for new trial on the basis of purely documentary evidence and essentially opened his findings of fact with a statement that he did not see a substantial need to make findings of fact about the contents of that documentary evidence because they were affidavits, not live testimony, and the appeals court would be equally well situated to determine what their credibility. It is the Commonwealth's position that in doing so, the judge, possibly in a good faith belief that that in fact the appeals court would have de novo review, but in doing that, the judge essentially abdicated responsibility for ultimately determining whether a new trial was in fact warranted on the evidence presented to him, and essentially that a judge in a case, even though this is a case in which there's been a suggestion of a recantation, that you do not automatically get a new trial just because someone has an affidavit saying they've recanted, much less an affidavit saying they've recanted plus the suggestion of re-recantation, that this is a situation in which the judge has to serve an important gatekeeper function of essentially determining, does this really warrant a new trial? And
did somebody testify live? I know there was a variety of affidavits, but I thought maybe somebody did.
Yes, the polygraph examiner testified live. The judge made detailed findings that the polygraph testimony was not admissible, and he stated firmly it was not a basis for his decision. He did say, nevertheless, on some level, it is of concern and makes the conclusion that justice may not have been done, in my mind, a more acceptable one. I suppose one could discuss whether that was in fact not taking it into consideration or not, but that was the only live witness, which he claims not to have taken into account.
So let's assume you are correct. Why is the proper course of action not to return it to the judge to make those findings as opposed to do what the appeals court did, which is to say the motion is denied?
Well, Your Honor, when the Commonwealth appealed to the appeals court, I was under the same misimpression as evidently the lower judge, and so I said, you have de novo review, see what you think. They noted that there is, in fact, a case establishing that when the judge has been the trial judge, he still gets deferred to, even if it's documentary evidence. In light of that decision,
I don't know about all documentary evidence, but certainly affidavits, which is what we're talking about here.
Okay, yes.
Right.
In light of that, having had that case brought to my attention, we are now seeking a remand. That it does ultimately, despite the judge's apparent, one could argue that he preferred to have this decided by another court, and that ultimately it is in his court, literally, figuratively, and he needs to determine exactly what he makes of the affidavits. Obviously, one can, but he needs to go further than he did in making some determination about why exactly he feels that they warrant essentially reopening a 10-year-old case where a trial jury would not necessarily have any better evidence than he currently has, beyond the fact that there's a lot of conflicting statements and it's justifiably confusing, that he has to serve a more fundamental gatekeeper function of trying to figure out, despite the unfortunate circumstances of the state of the evidence in this case, whether, the statement of the conflicting statements of the witness to the private investigator, which the witness then later adopted as signed under the pains and penalties of perjury, which the judge describes as a less than fully satisfactory affidavit itself, or the fact that the witness then told his therapist that the defendant was making him say it and that this was aggravating his PTSD. I think that those are very fundamental considerations that there has to be, that the judge has to grapple with in a more substantial way than he does. I know that my brother speaks about, do we really need the judge to use specific magic words? And I would say the judge does not. Rule 30 does require the judge to make findings of fact explaining his answer. I think that there's a certain obligation to explain oneself when one is requiring retrial of a case after all this time, and the judge is entitled to deference if and when he does it. but that where the judge essentially issues an explicit disclaimer that he is not reaching those issues, I think that at that point, no one else can, it's an unfortunate position for him to be in, but no one else can do it. No one else is better qualified to do it.
So what findings of credibility would you say he would have to make? I mean, does he need to say, I believe that the recantation is true, or simply to say, I believe that there's enough reason to think the recantation is true, that I can't be confident that justice was done here?
I think that ideally, I think that he should point to, this particularly raises an issue. Yes, I'm not sure. He can still not be sure what happened, but I think he needs to make specific points about why he thinks that the affidavits that favor the defense raise enough of an issue, and that the affidavits that favor the Commonwealth don't resolve it, or don't call it into sufficient question to sort of leave us back at square one.
Could he also say, I need to have more of an evidentiary hearing?
Oh, certainly, absolutely. I think that he emphasized throughout the hearings that he thought that the victim was really the only witness that would be of any use. And, I mean, he accepted, obviously, lots of affidavits, but that he didn't think that having the witnesses behind those affidavits would add anything. But if the Commonwealth would certainly have no objection, and I think that would be available as an option. Just as a sort of collateral matter, I know that my brother seems to suggest in his brief that the Commonwealth essentially procured the absence of this witness by directly threatening him with actively to charge him with perjury on account of either his recantation or his re-recantation. And the Commonwealth did draw the court's attention to the fact that the witness might have a fifth, but that's not the same thing as actively suggesting to the witness that he would be subject to be prosecuted by the Commonwealth should he appear in court. And once that issue had arisen, the witness's therapist had already requested that he be absolved from testifying because it was going to adversely would trigger his PTSD, because he told her that the defendant was making him do it. So I just wanted to lay out there that this is not, insofar as, clean hands are relevant in these cases, this is not a case in which the Commonwealth deprived the defendant of a helpful witness by badgering the witness. There's no evidence to support that. If there are no further questions,
Thank you.
the Commonwealth rests on its brief.
Good morning. I represent the appellee in this case. May it please the court. So in this case, I think it makes more sense to understand whether you want to call it credibility or viewing these affidavits as enough to show that justice wasn't done by what the judge did, in other words, ordering a new trial. Saying that I credit these affidavits is not anything that the judge needs to say. What we're looking at is the evidence that was before the court, and then look at the standard of review. And in this case, great deference is given to the trial judge. And in this case, you have a prosecution of this defendant, and the main witness against him has recanted consistently over a long period of time. And this, I think, allows a judge to say that, again, not having to use magic words with respect to crediting these affidavits, but just saying that enough of an issue has been raised that a new trial should be issued.
But when he explicitly says, I'm not considering the credibility of the affidavits, doesn't that sort of leave you in a no man's land?
So I took that to read like credibility in the sense that, what you would think of as crediting a witness. You look at the live testimony, right? You look at the way they act, the way they, the tone of their voice, all these sorts of subjective ideas that lead one to believe that, a person is being truthful or not. Here you have affidavits, and one could argue that it doesn't really make a lot of sense to say, I credit the affidavit. What might be better to say is that these affidavits carry the indicia of reliability, and because this witness, for reasons like a threat of, or maybe not a threat, but a fear of prosecution, for perjury. Mental or emotional incapacities also prevented him from testifying. The affidavits kind of were what the court had to work with. So credibility, I think, is a little misleading when he says he's not crediting the affidavits, but then he goes ahead and orders a new trial. I mean, judges don't normally order a new trial unless there's a basis to. And in this case, it ignores quite a bit of what the judge is doing to just say that, oh, he didn't credit the affidavits. Obviously, what he did was wrong. That I think is it's treating the trial judge, I think, poorly. Not
Well, there's a difference between saying he didn't credit the affidavit, so what he did was wrong, and saying he didn't make a judgment about the credibility of the affidavits, and we don't know what he based his decision on, because he didn't really, since that was the evidence before him, he didn't really take on what to make of them.
well. He does say, and these findings are reproduced in the transcript in the back of my brief. He goes into a lengthy discussion as to, I think, what he's doing. Certainly enough that shows what he's thinking and why he's doing it. Again, I think the problem here and the hook might just be just the word credibility, which I think shouldn't be such a snag because really all he has are affidavits, which seem to carry the indicia of reliability. I mean, you look at the affidavits that are coming in; they're consistent. They all tell the same story.
Except for the therapists, right?
What do you mean, except for the therapist? She's more concerned.
Recanting the recantation. Right? Doesn't he tell the therapist that he was being forced into doing this by his father?
Well, I mean, it's not that. Again, what we're looking for is whether he was truthful in the original trial or not, and that's really it. The therapist affidavit isn't helpful to say whether the son is being truthful or not. Just that he's feeling pressure.
You don't think it goes to whether he's being truthful in what he's been telling people when he's recanting?
No. As I read the affidavit, it was more in line with why he shouldn't testify because of his problems with his emotional problems. Mm-hmm. But you have, as I said, for example, the best one is obviously the investigator's affidavit, which is signed by the son and initialed by the son at the various portions. And these affidavits, they do carry the indicia of reliability. They're sworn to under the pains and penalties of perjury. And so it should raise in, I think, any judge's mind whether justice was done in this case.
Was there any testimony from the investigator?
No.
I mean, I understand that the boy took the fifth, so he wasn't coming in, although the
Right.
judge had hoped that his testimony would be had. But the investigator presumably was the defense investigator, and the defense investigator could presumably testify to the circumstances in which he interviewed the young man. And the judge could make some determinations from that, but that wasn't done.
No. Again, as I look at this case, everything comes down to the testimony of the son, whether it was truthful in the original trial or not, whether he was pressured and felt pressured to testify against his father or not, whether it really was his father who committed the crime or, as he says, was his uncle. So much of the law just depends on people coming in and swearing an oath and telling the truth. And in this case, where you have these recantations over time, and they're all consistent, again, I fail to see how any judge could ignore this and just say that justice was done in this case. It's up to the government to have to prove this case now that this person has recanted.
But certainly your position is not that a judge is obligated to order a new trial because there is an affidavit recanting.
No.
So there has to be some evaluation of the worth or reliability of that recantation.
Yes, which is for the judge to make in their discretion.
In their discretion, or are they obliged to do that before they order a new trial?
Well, the court in this case held a hearing and hoped that the son would testify, but as is in the transcript, he didn't. He had a right not to. And so now, at the best, this defendant, his son, has recanted. At the worst, we don't know whether he was telling the truth, either now or in the original hearing.
Yeah,
Either way, his credibility should be assessed by a jury.
But you make the point that his initial report might have been the result of him having been pressured, right?
When he testified originally,
Yeah.
yeah, there was in his affidavit he talks
You're
about,
suggesting he might have been pressured into saying that.
or he might have felt pressured, or he was led. Yeah,
Yeah.
you can get
But
those.
why couldn't you assume that his recantation was the result of pressure, too? Wouldn't it work both ways?
It does work both ways, but again, when we're here with a case where the government's their linchpin, the bulk of their evidence was this one son testifying as to his the memory of his events. Again, as I said, at best he's recanted. Okay, at worst we just don't know. And even if we just don't know whether he was telling the truth then or whether he's telling the truth now, there has arisen problems with the government's main witness that shows that justice may not have been done. In the end, what we're looking for is whether this defendant committed this crime to the best of our ability. And in this case, yeah, you're right. A judge looks at affidavits, and a lot of times, as the rule says, they can deny the motion just on the papers alone. But in this case, where you have so many people who are coming forward and saying, under the pains and penalties of perjury, that this was what they were told, that he wasn't.
Are you suggesting that that's really what the judge here did? He's saying it really is no longer clear when the truth was being told and when it was.
Yeah, he says that in his.
Yeah,
in his
and that is the basis on which I'm doing this.
Oh, that
It
is the
calls
basis.
into questions, right?
Yes,
So
we know.
that's-
We know that because that's what the judge said, yeah.
yeah.
And
Right.
again, don't get hung up on the word credibility. Otherwise, you're gonna miss the point here. The point is, again, whether justice was done. And when you have these affidavits and you read them, it's and even believing that he's recanted, that doesn't put me in any weaker position, I don't believe. Thank you.
Counsel, your time is up. Thank you very much.